Welcome to UCL from the Judicial Institute and the Centre for Crime. My name is David Ormerod, and I'm involved in the directorship of both those centres, and I will be chairing the event this evening. We have a large audience, not only here in the room, but also online, and that's true as well of our speakers. Some are here in person and some will be joining us online. And it's a pleasure to welcome such a distinguished panel of speakers ranging across legal academia, neuroscience, philosophy, and legal practice. And they will offer us, I know, welcome, Patrick, a range of views on how to understand and reform one of the most troubling issues facing the criminal justice system, which is how to regulate the evidence in prosecutions for sexual offences. And concerns regarding the efficacy of investigation, charging, prosecution and trial of sexual offences have been voiced, of course, for many years. But the government's end-to-end rape review just a couple of years ago brought that debate really back into the spotlight. And one of the issues affecting the rates of reporting and investigation and charging and so on is the way in which the evidence will be adduced at trial. That includes not only the evidence in relation to the incident, but of course the evidence relating to the complainant's credibility, broader material, perhaps the complainant's medical records, and sexual behaviour evidence of the complainant. And in seeking to reform the law on the admissibility of evidence in this area and its presentation in prosecutions, we need to have a really sound understanding of the way in which jurors approach such evidence. And that poses its own challenges. How do we guard against jurors adopting stereotypical myths and misconceptions, unfounded perceptions about complainants' behaviour at the time of the assault and in the investigation and trial? And as the Law Commission explains very effectively, very elegantly, the effects of the myths and misconceptions are pernicious and filter through the breadth and depth of the criminal justice system. They have an impact on the likelihood of reporting and the potential for investigation and charging and so on. And our panel this evening is uniquely well placed to address these issues. I'll introduce each panel member as they come to speak. We've got quite a tight timetable, so I'll do it on my best to keep us to time. Let me begin by introducing Professor Penney Lewis, who is the Criminal Law Commissioner for England and Wales. She was a professor at King's College London and director of the Centre of Medical Ethics there for many years. And one of her long-standing interests is in the uses of evidence in sexual cases, having published a monograph on this 17 years ago, I think. And as Commissioner, she's led the project on evidence in sexual offence prosecutions, which published in May of this year. That 700+ page consultation paper poses numerous questions as to the best options for reform. It's really bursting with impressive research, comprehensive coverage of comparative material, social science evidence, and so on. So for those of you who haven't yet read it, I encourage you to do so. If not the full 700 odd pages, then there is an accessible 56-page summary and an even shorter version if your time is so pressing. But I would urge you to read and respond. So, Penny, over to you.
Thank you very much, David. Yes, that's me. Let's see if we can get to the, there we go. How did we come to this point? So as David mentioned, the government's end-to-end rape review was had as one of its outcomes a request to the Law Commission to review the law in this area. We were asked to consider the need for reform to increase the understanding of consent and sexual harm, improve the treatment of victims, and while ensuring the defendant receives a fair trial. I think one of the things we tried to do initially was to look at the other attempts at reform in this space, and there's an appendix at the back of the 700-page consultation paper that provides a table. And our conclusion, having looked across all of these reviews, is that despite progress, there remains a real risk that rape myths contaminate trials, and complainants still experience poor treatment, unnecessary distress, and disproportionate invasion of their privacy. Our proposals aim to prevent rape myths from influencing trials, better protect complainants' privacy, and ensure that complainants are treated humanely and that defendants are tried fairly. Having said that, I'll try and unpack some of those conclusions in this presentation. I think it's worth stating here that although it's relevant to all of the aims of the project that are on the slide, the aim of increasing the understanding of consent and sexual harm most clearly raises the need to address rape myths and misconceptions about sexual offending in the criminal justice system. But not only within the criminal justice system. I think it makes clear that that needs to happen on a societal level. Okay, so as David said, we published a consultation paper in May. We're currently in the consultation process, so we're undertaking events like this. We're having meetings with consultees and doing public events as well. We would encourage you to submit responses to the consultation. You can, of course, answer all of the questions in the long version of the paper, but there is also a possibility of answering the smaller number of questions that are in the shorter version, and you can do that via a link from our webpage. Our aim then will be to provide a final report and recommendations for reform to government in the autumn of 2024. As you would guess from the fact that it's 700 plus pages long, it covers a lot of topics, some of which David's already mentioned. I'm only going to concentrate on two in this presentation, although I'm very happy to answer questions about any of our provisional proposals. They are myths and misconceptions, and then how to respond to myths and misconceptions in the context of jury decision-making. But as you'll see, there's a very wide range of evidence that we consider, and also more radical options at the end of the paper. I think it's also worth saying, though, that by limiting myself to juries and sort of influencing jury decision-making in this presentation, I wouldn't want to suggest that myths and misconceptions aren't relevant more broadly. So throughout the paper, for example, in relation to personal records, in relation to sexual behavior evidence, we consider the risk that evidence like that will introduce myths and misconceptions into the trial, or can be used to do so either intentionally or unintentionally. So myths and misconceptions are really relevant throughout. Okay, so if we start with myths and misconceptions, a sort of short word about terminology. I mean, we use the phrase rape myths because it's the most readily understood, but really what we're talking about is misconceptions about rape and sexual assault, which are beliefs which are genuinely and sincerely held, but factually incorrect and may be derived from stereotypes. Many of these misconceptions contribute to the idea that a real rape has certain features, or that a real victim or a real rapist would act in a certain way or have certain characteristics. As I said earlier, these myths are not peculiar to the criminal justice system. We're not in any way suggesting that jurors are somehow more prone to being influenced by misconceptions than anyone else. They affect the criminal justice system because they are accepted in wider society. And this, of course, raises the risk that they are accepted by people involved in the criminal justice system, whether those are judges, lawyers, defendants, complainants, and jurors. It's worth asking the question, I think, why is this particularly a problem in this context? There are misconceptions about many things in society. Why is it that misconceptions about sexual assault cause particular problems in sexual assault trials? And Professor Annie Cossins from the University of New South Wales sets out really usefully 7 characteristics or challenges that are associated with prosecuting rape and sexual offences that make these misconceptions more challenging in and of themselves. So typically there'll be no witnesses aside from the complainant and the defendant, a complaint that's not made immediately, no forensic evidence of the alleged sexual act, or the inability of forensic evidence to prove lack of consent, even if there is forensic evidence of the sex. No confirmatory medical evidence of the sexual act. The consumption of alcohol or drugs or both by one or both of the defendant and the complainant. Counterintuitive responses by the victim during and after the sexual assault, and word-on-word oral evidence. So the complainant and the defendant are telling completely different stories about what has happened, and there's really very little else to go on. Cossens concludes that the result of this is that jurors may fill in the gaps in evidence by relying on their biases and misconceptions in assessing the credibility of the complainant and defendant and in reaching a verdict. I think it's also worth looking back at an observation by Jennifer Temkin and Barbara Krahe, which was made in 2008, but still, I think, worth considering. They said, there's probably no other criminal offense that is as intimately related to broader social attitudes and evaluations of the victim's conduct as sexual assault. When confronted with an account of an alleged rape, individuals tend to respond to it against the backdrop of their personal beliefs and understandings about gender relationships in general, appropriate role behaviors for men and women, and the rules and rituals of consensual sexual interaction. So let's look now at some examples. In the full consultation paper, and to a lesser extent in the summary, we provide an illustrative list of some myths. And we contrast those, as is common, the CPS guidance on myths does a similar thing, with what the evidence shows based on scientific studies. So, for example, rape is most commonly perpetrated by a stranger. It typically occurs outside at night in secluded places. That's the myth. The evidence shows that the great majority of rapes are committed by persons known to the victim. Rape happens at any time of day. Most commonly, rape takes place indoors, and victims are often raped in their homes. The myth, rape always involves physical force. Rape may or may not involve physical force. There may be threats of force. Rapists may use manipulative techniques to intimidate and coerce their victims. Rape will always be physically and/or verbally resisted. Many victims do resist, many freeze through fear or shock. Some of you will have heard coverage on the Today program this week of sexual assault allegations at McDonald's restaurants. And I was taken by the fact that there was a young woman, I think on Monday's program, talking about her experience of being sexually assaulted at work at McDonald's. And she described exactly that. She froze. She just could not move. She didn't do anything while it was happening, and then eventually reported it. So many victims do resist, many freeze, or decide that resistance would be futile and/or dangerous. The victim may be afraid of being killed or seriously injured, and so cooperate with the rapist to save their life. Victims may become physically paralyzed with terror or shock and be unable to move or fight. Self-protection and defense can be through disassociation or freezing, any effort to prevent, stop, or limit the event. The myth, rape always results in physical injury. Rape doesn't always leave visible signs on the body or the genitals of the victim. A minority of reported rapes involve major external or internal injuries. Rape will always be reported promptly. Most rapes are, as I imagine many of you know, never reported. There are many reasons why people do not report or do not report immediately, including trauma, feelings of guilt or shame, confusion, or fear of the consequences. The myth, after rape, all victims react in the same way. Real rape victims will always be visibly distressed when describing what happened to them. The evidence, reactions to rape vary greatly. Responses may include extreme distress, quiet control, shock, and denial. The myth, allegations of rape are commonly false. The evidence, false allegations are very uncommon. The evidence does not support a generalized suspicion of rape complainants. And the final one in this set of examples, only gay men rape other men. Only gay men get raped. Men who rape other men are often heterosexual and their victims are also often heterosexual. So, how do we decide what the extent or prevalence of these myths are? I think the first thing to say is that there's a lack of consensus as to whether research demonstrates that jurors are or may be influenced by myths and misconceptions. And in the paper, we looked in detail across the evidence base. And I think it's worth noting, and I know that Lewis is going to talk about this a little more, that a challenge that's faced by researchers is that the law prohibits anyone from asking jurors how they reached their verdicts. So given this, studies have used mock juries to test the effects of myths and misconceptions. And an extensive body of research into mock juries has concluded that rape myths do have effects on mock jury deliberations and decision-making. And this includes the Scottish Jury Project, which found that, and I quote, even jurors who do not score highly on scales that measure attitudes in the abstract, so rape myth acceptance scales, can express highly problematic views when discussing a concrete case. A systematic review of the empirical literature in 2015 concluded that the mock jury research shows that there is clear evidence that rape myths have an impact on juror decision-making. I'll touch briefly on Professor Thomas's study because I know that she's going to be speaking later, so I don't want to go into that in any detail because it's better that you hear about that study from her than from me. But we did consider it in the paper, as indeed we considered any research that was relevant. And that study did involve real jurors. And it used a scale to measure attitudes in the abstract, because of course that was all it could do because of the prohibition on talking to jurors about their deliberations. And that study suggested that rape myths had far less influence than the previous research had indicated. Professor Thomas concluded that her research does not support the claim that jurors believe commonly held rape myths which lead to acquittals, or that juror bias is widespread. There has, though, been some recent research conducted with real jurors in New Zealand, where jurors can be asked about their deliberations. Judges were also interviewed for that research, and transcripts of the trial were reviewed. The researchers in that study concluded that their study supports the view that at least some significant degree of illegitimate reasoning does occur in jury decision-making in sexual violence cases. So we acknowledge the lack of consensus in the research. In our view, the evidence points to a likelihood that myths and misconceptions have some impact on juries. We conclude that it remains prudent to proceed on the basis that there are real risks that even conscientious, fair-minded juries with the best intentions may inadvertently be influenced by rape myths and misconceptions, and reform strategies should try to minimize these risks. We therefore consider and propose measures to counter the risks of myths affecting sexual offences trials, including the risks that juror deliberations are influenced by myths and misconceptions. Important efforts have been made already to try to address myths within sexual offences trials in England and Wales. The removal of mandatory corroboration warnings, the Rape Shield law, the current version of which is in Section 41 of the Youth Justice and Criminal Evidence Act 1999, but there was an earlier version of that, so it dates from long before that. CPS guidance identifying myths and how to counter them in case building and in advocacy. There's extensive judicial training, and judges can only sit on these cases once they have undergone that training. And then the example directions in the Crown Court Compendium, which address multiple myths and include a general direction which states, we know that there is no typical rape, typical rapist, or typical person that is raped. Rape can take place in almost any circumstance. We also know there is no typical response to rape. People can react in many different ways to being raped. These reactions may not be what you would expect or what you think you would do in the same situation. There are other example directions on delayed reporting, a complaint that's made for the first time when the complainant gives evidence, emotion or distress shown when making a complaint or when giving evidence, clothing, intoxication, previous sexual history, activity with the defendant, lack of resistance or injury, and the defendant being in a relationship. So you'll see that there's been quite considerable efforts to try and address a number of the myths that I enumerated earlier. And I think the consensus thus far is that no one single strategy will work in this context. Myths must be tackled on multiple fronts, including the rules of admissibility that we consider in other parts of the consultation paper, and also addressing their acceptance in wider society. So how does one address myths? How can we do that better than we're currently doing it? That's the task that we've been given. And we consider in relation to juries 3 ways of doing this. So one is judicial directions, which, as we've already seen, there's already considerable work in that regard. We look at to see whether that can be improved. We also consider alternatives, expert evidence, and education tools. When we spoke to stakeholders, there was real disagreement about directions, so about whether or not judicial directions are effective. Some stakeholders think that directions are hard for jurors to understand, that sometimes they're used inconsistently, and might not be capable of addressing myths and misconceptions which are deeply ingrained. Others told us that when suitably tailored to the facts of the trial, directions work well and are well understood. We asked in the consultation paper about some changes to the example directions in the Crown Court Compendium, so that the empirical research is better reflected, and new example directions for complainants that aren't yet represented, so male complainants and complainants with mental health conditions. In terms of expert evidence, currently, expert evidence explaining the general behavioral responses and psychological effects on victims of sexual offences is not permitted. It's regarded as being within the knowledge and experience of a jury, possibly to be supplemented with judicial direction. However, many commentators agree that juries need more assistance. We provisionally agree, as responses to sexual violence are complex, physical and psychological processes which are often counterintuitive. We provisionally conclude, therefore, that the necessity criterion of the admissibility test for expert evidence is met, and that such evidence could assist jurors in their assessment of the evidence. We asked about views about whether we've reached the right provisional conclusion in that regard, and whether the risks associated with admitting expert evidence are ones that can be mitigated. I'm almost done. Finally, we look at education tools. So, for example, a compulsory notice along the lines of the existing one, your responsibilities as a juror, or an educational video or online tool. In terms of jury research, I think I'll leave that to Lewis, but we do ask questions about whether more jury research should be permitted. And I think I've already pretty much covered the next slide. So it's worth saying that some of our work on other topics in the paper also relates to avoiding myths. And finally, this is how you can contact us. Whoops, now I've finally done it. There we go. This is how you can contact us. We do welcome consultation responses on any aspect of the paper. So there's no need to answer everything. If you have a specific interest, then by all means, just answer the questions in relation to that interest. And thank you all very much.
Penny, thank you very much. That was an impossible task, I know, in 15 minutes to summarize 700 pages worth. Let's move on. There will be time for questions and answers later. Let's move on immediately to our second speaker, Dr. Lewis Ross, a philosopher, currently an associate professor at the LSE. He has a wonderful web page for those of you who are going to Google him. It's one of the most interesting academic web pages where he invites people to start a beautiful correspondence with him and provides his email. His broad philosophical interests include work on ethics, law, and politics. And he's here this evening primarily because he has published recently, very recently, in the International Journal of Evidence and Proof, an article entitled "The Curious Case of a Jury-Shaped Hole, Making a Plea for Real Jury Research," which relates very specifically to this topic. And he concludes that there is a moral imperative to allow for the study of live jury deliberation. That was an argument I drew upon heavily in the lecture I was delivering publicly last year. Those in the room have by now or will shortly receive a handout. Philosophers still catching up with the technology. It's good to see they're using paper handouts. Those online, the PDF of that will be made available.
Great, so thanks very much for having me. So I'm going to talk in a little more detail about something that Penney mentioned about the extent and the evidence on the degree to which jurors are susceptible to rape myths. So the UK in some ways is unusual in that we retain a jury system, and the background, of course, is that in any jurisdiction that has a jury, there are perennial debates and concerns about the quality or the performance of the jury on a range of metrics, not only to do with sexual offences, but also to do with racial bias, to do with legal comprehension, to the understanding of complicated evidence, such as in financial crimes. And this is just one particular example of this long-running debate on the quality of juries. So there's a prominent and widely accepted view, both in the popular opinion, but also by governments north of the border in Scotland and also in England and Wales, that there are large-scale problems with criminal justice concerning sexual offences, with the highlight figures being that the sort of complaint to conviction ratio often falls below 2%. So naturally, we want to investigate this empirically. What's the cause of this sort of deficit? Is the jury to be blamed for this deficit, or should the blame be put at other parts of the criminal justice system, such as police investigations or such like? So there's been two high-profile research programs carried out north and south of the border. So the Scottish Government commissioned a series of mock jury programs. So mock juries are members of the public who are paid to evaluate fictional cases, sometimes being asked to sit in on reenacted trials. The Scottish Government funded and sponsored a high-profile mock jury program. South of the border in England and Wales, we're going to hear from Cheryl Thomas later. Her work, she was given approval to survey jurors, real jurors, after they had experienced a trial. They were surveyed as to their experience of being a juror. So these are the two high-profile government-sponsored empirical programs that have sought to address this question of, well, how well do juries do when it comes to assessing sexual offence cases? Are they making widespread mistakes because they believe in rape myths? The Scottish Government concluded that juries are, to a large extent, susceptible to rape myths and are currently trying to pilot a judge-only scheme for evaluating sexual offences, and are currently facing great difficulties getting that approved by other members of the legal profession, with various sort of criminal bar associations saying they won't support this case. And now the sort of subject of today's sort of workshop is the 2023 Law Commission report on sexual offence trials. The English and Welsh government is obviously more circumspect than the Scottish government in this respect, and I'm going to sort of talk a little bit about the state of play of the research. So Fiona Leverick, one of the prominent jury researchers, conducted a meta-analysis that the Scottish government relied on heavily, which claimed there's overwhelming evidence that jurors do suffer and are influenced by rape myths when they deliberate. However, what her research reveals, arguably, is that much of the ancillary existing research is of poor quality. So none of the 28 positive results that she canvassed contained any deliberative element. So in many cases, it was undergraduates being asked to read short written statements and then fill in question and answer forms. There was no deliberation, and there was no realistic trial enactment in any of these studies that's been widely relied upon. On rape myth acceptance and reluctance to convict, only 2 out of the 25 studies contained any time for the mock jurors to deliberate, and very few contained any trial reenactment. So these were highly artificial studies. And the wider background is that within social psychology in particular, there's been what's been called a replication crisis, where many results have been found not to generalize when studies are repeated. So arguably much of the pre-existing research in social psychology is of rather poor quality. However, that's not to say that the government-sponsored research is of poor quality, but there has been widespread debate about the ecological validity, or in other words, the sort of generalizability of this work. To what extent does this work really tell us much about the performance of live jurors rather than, say, mock jurors? And to what extent can we make inferences from these post-trial surveys to what jurors actually do in the secrecy of the deliberation room? And what we find is that there's disagreement between these two high-profile cases. So the mock jury research sponsored by the Scottish government found overwhelming evidence of rape myths, while the post-trial surveys conducted by Cheryl Thomas, who we'll hear from later, found that there's not strong evidence that jurors are heavily influenced by rape myths, right? And this is obviously a striking result. We've got two of the leading researchers on sort of jury science, both sponsored by their respective governments, and we find that they draw broadly opposing conclusions. And given that this is the two only high-profile government-sponsored research programs on these islands, that's a truly striking thing to find, that the two high-profile government-sponsored researchers reach more or less opposite conclusions. So the Scottish government-sponsored mock jury research was indeed very high quality. It contained lots of reenactments. They had real judges participating in the reenactment. There was plenty time for the mock jurors to debate and deliberate, and they paid actors to read from sort of carefully curated scripts to try and replicate the experience of a real trial. And they found reasonably substantial qualitative evidence that people were raising rape myths during the course of these informal deliberations. However, at the same time, these myths were also often challenged by the other mock jurors. So, for example, 80% of myths to do with resistance in rape cases were challenged immediately by other jurors in deliberation. And of course, this evidence base remains somewhat narrow. It's evidence base from simply one team concerning only around 30 panels, and it only concerns one fictional case. So in many ways, the pilot scheme that's been driven by the Scottish government has been conducted on the basis of what is quite a slender base of evidence. It's evidence from one study conducted on one fictional trial. So self-reports and post-trial surveys, you might think, sorry, we'll go back 1 second. Of course, before we move on, there's a crucial objection that researchers have raised to mock jury research for decades. And this is a sort of basic philosophical question you can ask about mock jury research. Do people tend to think and deliberate differently in high stakes versus low stakes scenarios? So everyone who participates in a mock jury study knows that it's merely a sort of experiment. They know that no one's liberty or sort of punitive justice isn't at stake. They know that they're simply considering something that's being played by actors in a script that's been curated. They know there's not actually any real crime that's been committed. They know there's not even any real right or wrong answer about whether someone is guilty or not. So the question is, if you think that people tend to deliberate and think differently in high stakes cases where there is a real crime and someone might go to jail for upwards of 3 years, compared to a case where they participate in a mock jury survey as of a weekend, then obviously there's going to be big questions about the generalizability of this type of study. So you might think, well, we should turn to post-trial surveys of real jurors. And I think this in some ways gets us around some of the issues to do with low versus high stakes situations, because of course we're asking people to reflect on their real life experience as a juror. But of course, this is an imperfect tool to study sort of deliberative reality, because what you're relying on is people's subjective impressions of how things tended to go. You're not actually getting to the meat of what was actually said and done in the jury room. And what's striking is that while the research in England and Wales found very little evidence of rape myth acceptance, post-trial surveys in New Zealand found evidence of quite egregious rape myth acceptance in the paper I've cited in the handout. So again, what you find is this large-scale confusion and contradiction if you look at the evidence space, and many sort of meta questions about whether the evidence is reliable in the first place. So there's a bunch of dangers, I think, here when you try to react to this evidence base. So there's obviously the large-scale danger of watering down protections against wrongful convictions. For example, the Scottish Government is obviously floating the idea of removing juries entirely, which risks creating a sort of tiered system for serious cases, where some serious cases receive the benefit of a jury while others don't. This might, of course, delegitimize convictions in the eyes of the public. There's also a danger of making a decision that will probably extend for centuries on the basis of limited or single team research. Legal reform is generally a slow business, and questions to do with the future of the jury are likely to be ones that are answered and persist for decades, if not centuries to come. So we're really at a sort of turning point in the public debate here, and it's very important not to make a decision based on limited evidence or evidence about which there is sort of large scale meta questions. And of course, it's also important not to fail to take, we shouldn't fail to take suitably bold steps to identify what is obviously a pressing policy concern and something that indeed has been claimed to have be facilitating widespread miscarriages of justice. So there's a few proposals I want to float, and these are, I'm told, considered radical, but as coming to this debate as something outsider, they didn't seem entirely radical to me, and I'm interested to hear what people's opinions are, especially from practitioners. So one is to facilitate what you might call research on real trials. So this would be to allow mock juries, members of the public who aren't actually selected for jury service, to watch and evaluate real trials with a view to empirically studying how they go about assessing these trials. The two big problems for mock jury research are, number one, cost. You have to pay actors, you have to generate scripts, you have to hire courtrooms, and also realism, because if you have to try and generate scripts and have actors that are convincing enough to make the mock juror and the person participating in the study think that things are suitably serious and real as to take it seriously when they're deliberating. So one thing you might do is allow mock juries to evaluate real trials and then study the mock juries who are evaluating the genuine trials as they happen. So of course, these trials occur naturally. There's no need to hire actors, invent scripts, or hire courtrooms to facilitate this. What's been evaluated would be completely real and serious. It would be a real crime and a real trial with real lawyers and a real judge. Of course, the mock deliberation of these sort of mock panels would have no impact on the actual real jury who would be in the courtroom doing their normal job. So you'd kind of offset worries there. But what you would be able to do is you'd be able to sort of modify the composition and nature of these mock panels, allowing sort of targeted testing of specific hypotheses, which is one of the great advantages of mock jury research, right? You can vary the instructions or the composition of the mock panel in order to test out different scientific hypotheses. Of course, the sort of philosophical question about high versus low stakes cases would remain. If you were to canvass mock juries watching real trials, the mock juries would, of course, have to be instructed that their decisions wouldn't have any impact on the actual outcome of the trial. So that question would remain. And a second question would be, well, it might be the case that you have to gain the consent of, for example, victims to facilitate their trial being broadcast to these mock panels, whether it be broadcast live or recorded and made available for researchers to use in mock jury experiments further down the line. There's questions about, would you have to acquire the consent of victims or other people giving evidence? And presumably the answer is yes, and presumably many people would be reluctant to give that type of consent. So a second proposal would be to conduct research onto live deliberations. So I think one thing that's striking for many outsiders coming to this debate is that they aren't aware that researchers aren't allowed to study what goes on in the jury room. Many members of the public I speak to are simply surprised that this is the case and that these debates are carried out without knowledge of what goes on in the jury room. So the most radical proposal would be to facilitate researchers simply studying live jury deliberations. I mean, the most unobtrusive way to do this would be to transcribe the content of deliberations, anonymize it, and then archive it for some period of time, making it available to researchers only after the legal case has ended and, for example, any appeal process has run its course. This would inherit most of the strengths of the previously mentioned real trial research. For example, it would be about something that's genuinely happening with a great deal of gravity. People would be deliberating about potential punishment of someone who's accused of a very serious crime. But most importantly, it would solve the perennial question for any type of jury research, which is the high stakes, low stakes case. Only by studying live juries as they actually deliberate do we get a sort of unvarnished insight into how people tend to deliberate when they're faced with these types of high stakes scenario. And more importantly, the precise impact of any other intervention we might use to address rape myths will always have this degree of uncertainty if researchers aren't allowed into the jury room to see how real jurors deliberate. There'll always be an element of guesswork unless researchers are given this type of access. And of course, it would also be a sort of invaluable source of insight into other issues concerning jury performance. So the legal comprehension of jurors, dynamics between real jurors, and also other issues of demographic bias, for example, class-based or racial bias, or perennial questions about jury performance. And this type of facilitation would allow researchers to say something about this, because of course, what I'm talking about today is just one aspect of the challenge to the jury system. And of course, many other perennial questions about the performance of juries that we want to answer as people interested in legal policy. So there's a few objections you might pose to the idea of real jury research, live jury research. And I want to very, very quickly go through them. So one common worry is that having the contents of live jury research exposed to the public would damage public confidence in real juries. It would make people think that juries are less good than they actually are. So to that, I would respond, well, it seems to be the case that the current state of play is also damaging public confidence in juries. We're regularly assailed in the newspapers by the claims that juries are failing fundamentally to do their job in sexual assault trials. So it can't be said that public perception is currently being supported by the status quo. It's also unsatisfactory, I think, for the public to have confidence in juries that is based on erroneous assumptions. If the jury system really is doing a good job, they should be able to withstand some public scrutiny with respect to how they tend to perform. And of course, there are other sort of more pragmatic ways this could be dealt with. Researchers could be bound to confidentiality agreements, and any academic publications that would result from this could be vetted before they're released, as is sort of often the case in other types of study. You might say, well, real jury research itself might be invalid. So you might say, well, even the act of trying to study a real jury would then render the study itself non-generalizable to a sort of real jury that isn't being studied by researchers. You might say even the knowledge that jurors have that they're being recorded might affect the way they behave. So of course, this would engender like a very broad skepticism about any social scientific research. It would mean that there's simply no way to do good social scientific research into juries at all. So to this, I would say, well, it's of course to record someone and to describe them is of course much less obtrusive than relying on them to sign up for a study and come down of a weekend and participate in a mock jury is much less obtrusive than that. And of course, generalizability comes in degrees. And I think this is surely closer, much closer to the truth than any other method will get us. The final concern, especially some government officials have raised when I've talked about this, is that it would constitute unfair interference into a criminal trial and would violate the rights of the accused. So of course, any other proposal we have to change the way that evidence is used in court comes with their own dangers of interfering with the rights that people have against wrongful conviction. And at least it's far from clear to me how unobtrusive transcription would inhibit accuracy in deliberation. So the most common things people suggest might happen is people would be incentivized to suppress rape myths because they know they're being recorded, or they might not mention the fact that they've conducted their own research on the internet. It's not clear to me that either of these things would inhibit accuracy of deliberation, and thus not clear to me that it would really contravene the rights of the accused against wrongful conviction. And to end, I think, even if you remain somewhat worried about this, I think there's a broader point here, right? Which is that we're making a decision that's probably going to be one that sticks around for many centuries. The background concern is that the current arrangements are facilitating miscarriage of justice and sexual offences widely for thousands and thousands of victims, and this is a persistent problem. So what we have to do is we have to think about this issue longitudinally. We're making an issue here, we're making a decision here that's going to last, it's going to stick around. So we have to balance the rights of accused and victims, not just today, but accused and victims across sort of decades to come. We have to look at this as a long-term public policy issue. As I say, this is sort of a decision for the centuries. And I think when we do make it, we want to make it on the basis of the strongest and most robust evidence possible. So I think, for example, proposals to scrap the jury based on research conducted by one team on one fictional case is far too hasty. And I think this is a time to really dig in and dig deep and do what I think could be a sort of game-changing program of real jury research that would allow us to make this type of radical reforming decision on the most solid empirical footing possible. Thank you.
Thank you very much. Can we move on now to our next speakers? In academic circles, just by way of brief introduction, there's often a lot of noise made about interdisciplinarity. It's a phrase that's bandied around perhaps too much. But the truth is, it really matters. And it's almost always the case that different disciplines will reveal a new understanding or a new dimension to our problem, our understanding of the problem. So I have great pleasure in introducing Ebani Dhawan and Patrick Hoggard. Ebani is a recent graduate of UCL, now at Duke University in the USA. Patrick is the Professor of Cognitive Neuroscience here at UCL. I'm not sure how they're dividing their time or presentation transatlantically, but I will hand that over to you.
Thank you very much. So Ebani, I think, is online. So hello, Ebani. I'm Patrick Hoggard, and I will be presenting. My day job is that I'm a psychologist and a neuroscientist, and I'm paid to research voluntary action. So I'm interested in what gives us, if you like, free will. That's a quite loaded term, but I'm interested in what makes some of our actions voluntary. And a very important way that we can investigate that is by drawing a distinction, or perhaps better, imagining a continuum between some actions, which we think of as reflexes, and which are not voluntary. So you can see here, for example, at the top left, the kind of test that a doctor might have done on you. You may remember when you're young, where they whack your knee with a hammer, they stretch your muscles, and that leads to a reflex that goes through your spinal cord, and you kick out with your foot. And if you're unlucky, you kick the doctor in your face, in the face. And the other figure is a figure that goes back to Descartes, of the reflex that makes us drop the hot pan or withdraw our limb if it gets burned. So those are reflexes. They're automatic responses to external stimuli or triggers, if you like. And some of our actions are like that, but quite a lot of them are not. And the distinctive feature about the human brain, which is my interest, is how many of our actions seem to be up to us. They're not dependent on the external environment. They, as it were, come from within us. And a really nice example is the penalty shootout. So there's lots of stimuli and lots of environment in the penalty shootout. But the whole point about the penalty shootout is this person in the middle in red should, if they're good, they should choose either to shoot for the top left of the net or the top right of the net. And that's entirely up to them, which of those two they choose. And in fact, it's really important that they, for example, don't respond to somebody else in the team shouting, "Go for the top left," because then the keeper will have heard that and will have moved to the top left. So for many of our actions, it's really important that they're up to us and that they're, if you like, endogenous, that they're freely chosen based on maybe our deliberation or our conscious thought. And it is these kinds of free choices which we think of as giving us things that we're responsible for. So it's the fact that our actions are voluntary, chosen by us and up to us, which makes us responsible. So now we're beginning to get a little bit from brain science towards law. As far as I can see, the law assumes that our actions are volitional by default, or at least most of our actions are volitional by default, but the law does recognize some cases where strong external triggers can potentially reduce responsibility. So I've been interested for a while in the concept of the loss of control as a partial defense for murder. And in these kinds of legal arguments, the law seems to recognize that under circumstances of threat, or a threat can act as a trigger for particular kinds of actions. So I think what the law is saying is that, normally our actions are along at this end of the continuum between volitional and reflex, but there can be particular circumstances or triggering circumstances like threat, which push our actions back towards being more automatic and perhaps therefore make us less responsible. So here's a figure from a paper that Julia Christensen and many other colleagues have written, which is trying to look from a brain science point of view at the loss of control defense and the role of particular emotions such as fear and anger and their implementation in the human brain, and trying to understand whether there's, if you like, a neuroscientific basis for the loss of control defense. And in doing this, we hit upon something more or less by serendipity, which seemed to us really interesting, which is freezing. So under circumstances of severe fear and threat, people might freeze. This is not the main topic of this paper, but it got me thinking about freezing during rape and sexual assault. which are very common, as Penney has described, and which we may be able to consider as an involuntary automatic behavioral response to the threat represented by the aggressor. Now, under such circumstances, it seems as though there's an inability to make voluntary actions. It seems as though the victim omits to make voluntary actions that one might have thought they would. You may remember the very tricky question that was asked in the E. Jean Carroll trial: why didn't you scream? All right. So we have written a paper on this, which I'll show at the end, but we've unfortunately decided that there's no good term, and we've coined a new one, IRSA, immobility during rape and sexual assault. So rape and sexual assault victims widely report freezing. I'll give you some incident statistics later. This seems to be characterized, if you look at self-reports, victim self-reports, as an inability to move despite a wish to escape, cry out, or struggle. So there's a whole set of actions that the victim sort of wants to make, or is motivated to make, or desires to make, but doesn't. And we read several cases which in case law which describe these kinds of situations. And here's one: I just frozen away, like I was just scared, and like I didn't know, and I didn't know what he could do to me. Notice the word just, which comes up a lot in these legal cases. So the thing that's interesting here for me, as somebody who works on the cognitive neuroscience of being volitional, of being in control of our actions, is it looks as though there's a loss of agency during IRSA, during immobility, during rape and sexual assault. And it seems to be hard to understand exactly what it is. So the victim often can't really give a clear explanation of their own freezing. One gets the impression the court often doesn't quite understand it, and one certainly gets the impression that society at large doesn't understand it. And I think there are several reasons for this. The first one is the rape myth, that if you were being raped, of course, you would struggle. And the idea that there must always be a struggle and a violence component. A very important part is that for the victim, the rape or sexual assault is a traumatic memory. And we know a lot about traumatic memory. It's difficult to form coherent memories of really traumatic and particularly unpleasant painful events. So those of you who have been unlucky enough to be in a car crash will quite possibly have very confused memories of exactly what happened and what happened before what. So the victim is often seems to struggle to give a clear description of exactly what it was that happened, including their own immobility. And then I think, I mean, I said at the beginning that, you know, our actions are assumed to be volitional by default. So we are lucky to have the capacity to control our lives, and we can't remember the time when we couldn't, right? So if you look at a baby doesn't seem to have much volition. It doesn't seem to have much voluntary control over its actions, but we can't remember that. Childhood amnesia means that our memories and our autobiographical sense of self is strongly correlated with our ability to make actions, to do things that we want. So we ask a question in class, or we smile at our mother, or we get something nice. So agency is fundamental to all of our waking life and our memory of everything that happens to us. So it's extremely strange to lack agency. It's like being temporarily paralyzed, presumably. I don't know, it hasn't happened to me, I'm lucky. So the strangeness of losing one's default background agency and ability to control one's own body, I think, is one of the reasons why immobility during rape and sexual assault is poorly understood. It's just difficult to know what to say about it because it's so bizarre, presumably. Here is an excellent study by Muller working at Karolinska in Sweden. So the Swedes are very good at this kind of thing, apparently because Swedish people are used to things being measured all the time. It's the tradition of the Lutheran Church to sort of take lots of measurements and survey what people are doing. So it's a good place for social science data. And she has been involved in a clinic in Karolinska, which is an emergency clinic which deals with rape and sexual assault cases. And 48% of women attending the clinic appeared to display what she calls, and many other people in the literature call, tonic immobility. So this is this freezing behavior. during assault. I prefer the term immobility during rape and sexual assault, URSA, but tonic immobility is widely used in the literature. And there's some good statistics here where she characterizes, or she differentiates between the cases where there is tonic immobility, so the victim freezes, and the cases where the victim doesn't seem, based on self-report during interview at the crisis center after the assault, doesn't seem to have displayed tonic immobility. So the immobility behavior seems to be associated with previous trauma. So these are the odds ratios. So earlier sexual assault, twice as common in the people who did show immobility as in the people who didn't. It's interesting, it's associated with PTSD in the victim, and it's associated with poor outcomes. So it's clearly important clinically as well as legally. Interestingly, there's no association with alcohol intake. I think that's extremely interesting. And there's another study, here's the reference, which suggests that if you use questionnaires about self-report questionnaires about rape and sexual assault experiences, it seems to be not associated with the subjective feeling of fear. I find that really interesting. I'd like to know more about that, but it seems as though the freezing behavior doesn't seem to be strongly correlated with panic and fear during the assault itself. Now, one thing that I've not found at all is any stats, any quantitative data on the relation between the freezing behavior and the legal outcome. Are cases where there's freezing, are they more likely to proceed to a charge? Are they more likely to proceed to a conviction? I think that's really interesting and important to know, and potentially a way of looking at how severe rape myths are. So I'm a neuroscientist. I believe that our behavior comes from the actions of our brain, and the neural mechanisms of freezing therefore seem to be extremely important, and I think they're relevant for law as well. There are two ways that this can be studied. So one is to study this in animals. So animals freeze. You may have heard of the fight, flight, freeze response, the rabbit caught in the headlights. And you can do studies of freezing in animals, and you can apply severe threat to animals as long as you follow, of course, the ethical provisions of animal research. And you can also invasively record or manipulate different brain areas in the animals while you're doing that. And you can try to identify the brain circuits which makes the animal freeze, which are responsible for the freezing response. So that's one long and very interesting tradition. I'll present a little bit of data from that in a second. And you can also do experiments with healthy human volunteers, but you can only use moderate threats, and you're only ever going to get brief freezing-like responses. So for obvious ethical reasons, there's a real limitation on the ability to get experimental data on the freezing responses that we want to understand in the context of rape and sexual assault. So in the paper that we've recently published, we've proposed a neural circuit shown here completely schematically for freezing, for immobility during rape and sexual assault. So here is an aggressor, and you have visual and other sensory experience of being aggressed. And the key structure on the input side is the amygdala. So we know lots and lots about the role of the amygdala in the animal brain and in the human brain for mediating fear and threat responses. That's where all of the clinical psychology focus on PTSD and so on is. It's on the amygdala. There are good reasons for that. But what has been much less studied is the effects of the amygdala on our movements, on our muscles. And recent studies have shown that there's a structure in the brainstem called the periaqueductal gray, which just very recently we've discovered sends signals to nuclei in the brainstem, which mediate our ability to make voluntary actions and for our brain to talk to our muscles. So our brain talks to our muscles. I'm being a little bit sort of anthropomorphizing here, through these two pathways here, which seem to be potentially blocked or inhibited by the action of the fear threat circuit through the ventrolateral periaqueductal gray. So there's a potential inhibitory effect of the threat and freezing circuits on the voluntary motor action circuit. Maybe that's why you can't move. So the brain's threat systems inhibit the voluntary motor system. We know from animal research where the sort of synapses, where these points of interference might be. We can't, of course, study them in humans, but the threat system potentially blocks the individual's normal capacity for voluntary action. Maybe that's what immobility during rape and sexual assault are. And this leads to some quite interesting perspectives and future directions because of the way that the law treats voluntary actions and the way that the law sort of deals with the extent to which we're volitional or not. Immobility during rape and sexual assault seems to be an involuntary response to severe threat, which affects the victim's capacity to act. Why didn't she struggle type of arguments remain common, even in those legal systems which define rape based on consent, rather than legal systems which define rape based on violence? And I think that we think that a modern neuroscientifically based understanding of immobility during rape and sexual assault suggests that these arguments are misplaced and potentially disingenuous. Why? Because the victim does not have the capacity to make volitional action during the time that they are frozen. So they are, normally when you say, why didn't you do this or why didn't you do that, you're imagining that the person has the capacity to make a voluntary action. It seems to me that there are neurobiological reasons why the victim may not. An improved understanding of IRSA could be useful in victim support and counseling, in police and jury education. There's actually already one very good study from US in which policemen were informed about the fact that the freezing response exists. And I think it's relevant to legal argumentation. And I think acknowledging IRSA may lead us to favor legal definitions of rape and sexual assault that are based on explicit consent, rather than those that make reference to violence. And there's a lot of interesting change happening at the moment. So you may know about the law in Spain, which has recently been rewritten and which we cite in our paper, and which mentions clear acts of explicit consent. And interestingly, in Switzerland, after we published our paper, we were contacted by some journalists in Switzerland who reported that the Swiss federal parliament had recently voted a no means no law on rape, as opposed to the Spaniards who voted an only yes means yes law. But the Swiss law, the no means no law, includes a special mention of what they call état de sidération, which is basically freezing. So it's in the legal text, this sort of neurobiological concept of the freezing response. I haven't actually read the law, but that's what I understand from talking to people in Switzerland. So here is our paper, Neuroscience Evidence Counters a Rape Myth. Here is a DOI, which you can use to get it. And the project was done jointly with Ebani Dhawan as an undergraduate thesis at UCL, and she was extremely important in helping with reading the case law and with helping us work out the neural circuit, where we had to try to combine what we know about the animal brain with what we know about the human mind and the human brain. Thank you very much for your attention.
Patrick, thank you very much. Ebani, if you're online and listening, thank you very much as well. It's a very readable paper for somebody who has no neuroscientific understanding whatsoever. I say that it's a short and accessible paper. Let me turn now to some practitioners' views. I'm delighted next to welcome John Riley, a barrister for 40 years with long experience of prosecuting and defending in a wide range of criminal cases, but he is a particular expert in the most sensitive criminal cases involving sexual offending. I first met John, I think, in 2003, when we were training on the recently enacted Sexual Offences Act and the Criminal Justice Act. And since then, I've come to regard him as something of an oracle on the practical, deeply practical matters involving sexual offending. His expertise has led to him representing the Criminal Bar Association for many years on government consultation committees and various other non-governmental organisations. And I hope John, who we can see in the room here in the...
Okay, as I was saying, a little harsh on the 40 years, but you know, I think it's nearer to 30, but that doesn't matter. As David says, I've been in practicing in the criminal law and specialising in RASO cases for a very, very long time. Even when I was in the CPS in its very earliest stages, I was part of an office where we were asked to put together a training package for police officers and social workers who were then using the Memorandum of Good Practice, which was the forerunner of achieving best evidence. So I've been steeped in this sort of work for a very, very long time. When I came back to practice in '93, I on purpose dedicated the rest of my work to RASO cases of varying degrees of complexity. And I've done hundreds of rape trials, both prosecuting and defending, a fact which comes as a surprise to a lot of people, that barristers, of course, prosecute and defend very often in equal measure. When the 1999 Youth Justice and Criminal Evidence Act was introduced, a number of us, I was the most junior, His Honour Judge Peter Rook, Casey, Professor Laura Harno, David took part in some of this training, and others, went on a sort of countrywide tour teaching the bar about the new Act and Part 2 and special measures and vulnerable witnesses. Since then, it's my belief and impression that the bar, the CPS and the criminal justice system have made great strides in this area, very often great strides which aren't really terribly well acknowledged. Over the past few years and more recently, there's been a significant wave, almost a tsunami of critical comment from any number of sectors, academics, interest groups, victims groups, the press and others, about how the criminal justice system is dealing with and apparently failing in rape cases. And it is, of course, rape cases that are the focus of attention. It has been a narrative which I'm afraid I think has been very damaging to the public understanding and confidence in the criminal justice system. There's been a relentless battering of courts and the profession as to conviction and acquittal rates, how complainants are treated, how evidence is collected, how investigations are conducted, and the criminal justice journey of complainants through the system. Some of the harshest criticism, of course, has been reserved for juries and their ability to deal with RASO cases, but only in a certain way. There seems to be a perception that juries don't convict on the evidence of rape complainants, and my experience over my career, and certainly as of about 4 o'clock this afternoon, is just not true, because I've just finished a 3-week child rape case where the jury convicted on all 13 counts and took 3 days of exceptionally careful consideration while they were deliberating. The slightly concerning refrain of "we are not convicting enough rapists" has got into the public psyche in such a way that many women and girls are not inclined to come forward to report sexual offending. As was explained to me the other day by a local women's group I was speaking to, they told me that they knew that the conviction rate for sex offences was between 3 and 6%, that victims are always treated badly in court. And when I pressed them on this, they said, everybody knows this to be the case. It is not my experience that the conviction rate has ever been in single figures. And indeed, talking to colleagues in the CPS, they regularly report that certainly conviction rates in relation to what I call stranger plus cases are in the sort of high 60s and 70s and sometimes above. The conviction rate for rape cases is difficult, and there have been all sorts of different accounts of what it is and what it isn't. But as I say, I think the bar and the CPS and the criminal justice system have made great strides in this area. I must confess, as a practitioner of long experience, I am unsure about what a notional and acceptable conviction rate is and what it is meant by "we are not convicting enough rapists." The criminal justice process cannot offer a guarantee of confirming a true complaint, because obviously it deals with evidence of the complaint or of the complainant, all of the evidence, and it has to be tested by a set of evidential rules and practice, by an assessment by a jury of people involved in the case, and they are assessing the witnesses. As a starting point, complainants are often poorly informed as to what to expect from the system and indeed how it works. Sadly, complainants often seem to be made aware of the likely issues and components of the system of which they are the integral part in their case, only shortly before trial when they speak to prosecution counsel. The subject of this event, Juries and Evidence in Sexual Offence Prosecutions, suggests in some way that there is a problem with juries, and the discourse from external voices seems to go like this: the conviction rate in rape trials is unacceptably low. I don't see that it is. Something is going badly wrong. Someone must be blamed for this. Is it the police? Is it the CPS, prosecution counsel? But it's more likely to be the jury. My experience of conducting hundreds of rape trials is that the jury is not the problem. I've watched juries. I've seen how they deliberate. I've seen how they react to evidence. Obviously, I haven't seen how they deliberate, but I've heard the questions they ask. And again, just using my most recent case today, the number of questions that they asked and the types of questions really showed that they were completely engaged and were asking all sorts of interesting questions that we had to answer. Equally, their demeanor throughout the process is valuable as a way of determining, from my point of view at least, what they are thinking and how they're going about their job. And it is my frequent experience, in fact always, that I believe juries do follow judicial directions and directions, and the advent of giving juries routes to verdict and directions in a split summing up has helped them enormously. So if it's not juries, what is the answer? Indeed, is there an answer? Well, I think there is. And a lot of my colleagues also think the same thing. It's got far more to do, I think, with what a jury is presented with, because they have to make the decision based on the evidence. And I think we do not prepare complainants, prosecution witnesses, particularly well. When I compare what I can do with the defendant in terms of preparation, in terms of engagement, in terms of getting them involved in the case, as opposed to what I can do with the Crown's principal witness, it's very, very different. Of course, the roles are different. We all understand that. But I think that one of the answers to helping jurors and juries do their job perhaps even better is to provide a much higher quality of evidence and presentation by complainants in rape cases than they get at present. I've had a lot of post-trial complainants come and talk to me or ask to talk to us about their experiences. It's quite interesting that very often they are not necessarily or wholly focused on the outcome, but they are very interested in their journey and how they were treated. And more often than not, their real concern is that they were not helped to engage as much as they would like, even to the extent of all too frequently being told that they should not sit in court after they've given evidence in order to be able to hear the rest of their case. I must confess, as a prosecutor, I'm not very keen on having called a witness, used special measures for them, and then for them to be seen to be sitting in the public gallery, that it gives a terribly good impression to the jury. But there are ways of being able to allow complainants to listen to the rest of the case without them being in a public gallery and seen, and we need to look into that ever more. So I think that the better route, perhaps, rather than trying to divine how juries deal with their task, is far more to provide them with even better evidence and presentational methods. So allowing complainants in rape cases, as I say, to listen to the rest of the evidence, and perhaps in the same way that a defendant would give information, give instructions to defense counsel, complainants have said to me, why is it that I can't speak to prosecution counsel about other evidence in the case that I've heard when I know it's wrong, or I think they should be helped, or that, or what's being said is not my understanding of what happened. Finding better methods of complainants being able to give their evidence is the key. And one problem that we're finding, and again, it's an impression that one gets from experience and practice, is that we have on the altar of special measures in trying to help the presentation of evidence, we've sacrificed the interaction between juries and witnesses. And just one thing that occurs to me, juries are not some sort of other animal. They are us, they're all of us, and they're not a sort of species apart. So they are the makeup of the public. But as I say, one of the problems is that now that we've got Section 28 and it's being rolled out, and it seems to be the answer to all the government's prayers about dealing with the backlog and so forth. But you can very regularly now have a situation where the principal prosecution witness is recorded in an ABE that's dealt with by the police, that their cross-examination is recorded, and there is absolutely no possibility of that individual person interacting in any way with the jury, as it were, eye to eye, face to face across a courtroom. Whereas the defendant is always in court, looking at the jury, as we tell them to do, answering the questions that they're being asked by looking at the jury, and taking a full part. So we need to look at that whole scenario as far as the distance that we are imposing upon the principal witness for the Crown in rape cases. So my suggestion is that we look at far better methods of presentation and preparation for complainants. We get them much, much more engaged in the prosecution process. And by that way, I think we help the jury much more, because of course, if you put the wrong ingredients into the oven pan and your Yorkshires don't rise, there's no point in blaming the oven. So getting the ingredients right is the answer, I think. Thank you very much for listening.
John, thank you very much. We've already had a question in relation to that, which I'll save for the Q&A later. Can we move now to Professor Cheryl Thomas, Professor here, of course, at UCL and Director of the Judicial Institute, and her pioneering jury research in the last 20 years or so in England and Wales has been hugely influential in the way the justice system has dealt with so many aspects of jury behaviour, and indeed in criminal trials more generally. We've heard a lot about her research already, but we can now hear an authoritative account from Professor Thomas, who I hope can hear me.
I can indeed, David. Can you hear me?
Hear you. We can. Thank you, Cheryl.
Fantastic. Thank you. Well, first of all, thank you for inviting me to take part in this. I've enjoyed and been fascinated by all of the presentations so far. I'm going to attempt to share my screen, which I hope is going to work. There have been some discussions already this evening about one small piece of research that I've done in relation to juries over the last 20 years. And I actually think, I thought it would be perhaps very helpful to really just cover two things, which is stepping back a bit and saying, you know, what is the UCL Jury Project? What do we do? How do we do it? And why do we do it the way we do it? And as David very kindly said, we have been conducting research with real juries at court for over 20 years. So the discussion around one particular study that was done a couple of years ago, pre-COVID, in relation to jurors' attitudes to sexual offences, forms really just a small part of a much broader research project in relation to juries in England and Wales, and to say that we have also done research with juries in other jurisdictions in the UK, including Northern Ireland. I'm going to start with the myth about research with real juries. So we have heard that, and it is in fact the case, that it is a criminal offence in this jurisdiction to obtain, disclose or solicit information from jurors about what they said or did and votes that they might have cast in the course of their deliberations. Now, I've been talking about this actually for about 20 years, which is that there is a myth that this means that somehow it's impossible to conduct research with real juries. So over the last 20 years, we have been, we have no special dispensation from that legal provision, and fully within the bounds of that legal provision, we have conducted very extensive research with only with real juries at court. We don't use any other proxies for juries. And that's allowed us to look at a wide range of issues that are really focused on understanding how juries do their job, understanding whether there are any potential issues with juries doing their job? And if so, how can we give them better tools to do their job? So for instance, just in general themes, we've looked very extensively at jury processes, and that includes the whole summoning process, as well as the whole experience of serving as juries. And that includes jury decision-making, and I'm going to say a bit about methods used with real juries in relation to jury decision-making. We have also done quite extensive research on jury outcomes and the impacts of juries. So we have extensive amount of analysis on actual jury verdicts over an extensive period of time. And then we have looked in surveying jurors post-verdict or interviewing them about their experiences and their needs, and also their attitudes, both to their role as jurors and in the job that they have in terms of reaching verdicts. So this is just a short list of some of the issues that the UCL Jury Project has been able to examine with real juries at court in England and Wales over 20 years. We started out actually, and the whole project started post the Macpherson report, when the then Lord Chancellor, Lord Irving, wanted to see whether there was any evidence of institutional discrimination in the court system. And one of the things that he asked was that there was detailed empirical research on whether there was evidence of racial bias in the jury system. And that was our first big project. We've also looked quite substantially at the representative nature of juries, basically following everyone who's summoned for jury service all the way through to who doesn't end up doing it, who does do it, how representative those pools of juries are at each individual Crown Court throughout England and Wales. Juror contempt has been a big issue in more recent years, concerns about the impact of the internet and social media on the extent to which juries need to confine themselves to the evidence in court and not go trolling the internet to look for information about their cases. We've done a lot of work on jurors' understanding of the law, and particularly their legal responsibilities to help ensure that they don't commit contempt. A lot of the work has been fed into changes in judicial directions. So 20 years ago, when I started this research, juries were very, very rarely provided any written directions when they went into the deliberating room to reach their verdicts. Now, I would say that in virtually, 99.9% of cases, all juries will receive some form of written direction from the judge, and that's a massive sea change. We've looked at the impact of jury service on jurors themselves, both the positive and negative experiences they might have, and we've done research on jury deliberations, specifically what jurors have to say about whether they're given enough guidance and so on jury deliberations. And then most recently, we have done some research. I have to say it was not government sponsored, Lewis. It was a request by the judiciary, and it's also part of a wider Nuffield project, but that's, we've looked at rape and sexual offences, and I'll talk about the results of that in a minute. But I wanted to really just say a few words about the research methods that are used when you do research with real juries. And there are three basic methods. The first is very large-scale data analysis, and I'll explain some of the key findings from that. But we're very fortunate to have MOU with the Ministry of Justice and HMCTS, and they share the court data from the Crown Court with us, and they've been doing that since data from 2006 through 2023. So that provides a very large scale data set that enables us to look at a lot of interesting trends in jury decision making. As you will have heard, we also conduct post-verdict surveys with juries at court. And then the third method is a case simulation. I'm going to explain a little bit about that in a minute, but that is also sometimes referred to as mock jury research. But in this case, it's not mock jury. We only do our case simulations with actual juries at court. And our approach to this is that if there's an issue of concern, that it's important to not just rely on one of those methods to try and reach some conclusions about whether there are problems with the jury system, that the strongest findings are those that have some consistent results across at least 2, if not 3 of those methods. And that's our overall approach. So just to say a couple of words about how large-scale data analysis works. So as I said, we have a data set that includes every single charge against every defendant in every Crown Court in England and Wales from 2006, well, halfway through to 2006 to 2023 now. And just to say some of the issues that we have been able to reveal in looking at that data set are things like the volume and nature of charging in the Crown Court, pleas, are there differences in pleas based on offences, based on defendant background, and certainly in that case, we did quite a bit of research for the Lamy Review, and that highlighted that ethnic minority defendants were very significantly more likely to plead not guilty in relation to almost all offences. So we're then able to trace all these charges through past plea to which charges end up actually resulting in a jury trial. And then if those charges end up being decided by jury deliberation, so not all charges that are against a defendant when a jury trial starts inevitably end up being decided by jury deliberation. And that then allows us to look at jury conviction rates and, much sort of deeper analysis of those conviction rates, perhaps by offence, by court, by different profiles of defendants. There's data in there, obviously on ethnicity, but also gender and age and so on. And it allows us to look at things like hung juries and majority verdicts. And just to share with you, some of the, I think some of the more interesting results on jury conviction rates. This is research that, or the finding here is a research that we revealed way back in 2010, is that the most significant factor in jury conviction rate is the offence. So that's as opposed to the court where it's being tried, or the region of the country, or personal background factors of defendants and so on. And I just really wanted to share with you here what the highest and lowest jury conviction rates are by offence. So you can see there's quite a substantial variation in the overall conviction rate, jury conviction rate, according to the offence. We're happy to discuss this later, but I think people can perhaps draw some very obvious conclusions here in terms of the types of evidence that's put before a jury with the very high conviction rates and the nature of the offences that the juries are having to decide that have the lowest conviction rates, very much those in red being the ones that tend to be one person's word against another. And again, just to give you a little bit of a highlight of how we can use the data set, this again was for the Lamy Review, in which we found no strong correlation between the ethnicity of the defendant and jury decision-making, virtually identical jury conviction rates based on the ethnicity of the defendant. And that went across the board regardless of the types of offence. So that's how we use the large-scale data set. Immediate post-verdict surveys. Well, what can and can't you understand from this? They can be incredibly valuable for exploring things like juror understanding, juror awareness, their views of the process, their conscious awareness of their needs. And that can relate to the types of directions they get and also the support they get, their attitudes in relation to doing jury service. And in this instance, one of the studies that we did looked at their attitudes to sexual offences and their experience of jury service. But making the point that post-verdict surveys or interviews with jurors are not designed to look at jury decision-making. It is not a good method for doing that. And that really brings up another myth, which is, I've heard this pretty much over 20 years, over and over again, that, if only we could ask jurors about what they talked about in the deliberating room, or if we could only, listen in, that somehow we were going to really have a very clear idea of how juries reach decisions. And I've just noted that the Law Commission report does also mention this. So just to explain a bit about why it's a fallacy that hearing about what you can actually understand from hearing about deliberations. And I think the perhaps Patrick and certainly others, if we've got some psychologists in the room, would attest to the fact that it's a very well-known phenomenon that as humans, we simply cannot consciously know all the factors that influence our individual decisions. And that means that we simply are not going to be in a position to accurately articulate them if we're questioned after the fact of our decision. And if you apply this to the jury situation, jury verdict is therefore even more complex as a decision-making process because it's ultimately a combination of 12 individual decisions that result in a 13th decision, which is the group decision. So simply being able to speak to jurors post-verdict and say, oh, why did you decide the case the way you did, is really not a very methodologically sound way of trying to understand jury decision-making. There's also an issue about what happens with hearing or getting post-deliberation reports about the views that were expressed in the deliberating room. And the reality is that jurors may express views in the deliberating room, but you cannot necessarily draw an immediate connection to a view expressed to the actual decision that the individual came to, never mind the verdict of the jury. And I think it's really interesting that we've starting to hear quite a lot about the research that was conducted, very interesting research conducted a few years ago in New Zealand. I think Penney Lewis had mentioned this in her presentation at the start of this evening, that there's some sense that, well, this was so radically different and so much more effective because they could ask jurors about what was discussed in the deliberating room. But what's really interesting about that article is the authors themselves actually acknowledge that, well, while they heard what they refer to as cultural misconceptions in relation to rape and sexual offences, while some of the jurors that they spoke to post-verdict expressed those views or said others expressed those views, the authors came to the conclusion that if any of these cultural misconceptions were expressed in deliberations, it was not possible to draw conclusions about whether these actually influenced jury verdicts. And then if we sort of turn to the idea of recording jury deliberations, well, for the very same principles, looking at transcripts of what individuals said in deliberations, I think are equally ineffective in understanding the factors that actually influence jury decisions. If you think of the dynamics of 12 people sitting in a room, some people will speak more often than others. And also people are not necessarily going to articulate or even be able to articulate in a jury deliberation all of the reasons that have played a part in their decision making. And I do think we really do have to raise the issue of the ethics of surreptitiously recording jury deliberations, or if it's not surreptitious, we have certainly asked jurors post-verdict for many years what their views were about the recording of jury deliberations, because this was discussed probably about 10 years ago in some policy discussions about whether jury deliberations should be recorded, really for legal purposes, for reference later when there was concern about juror contempt. And I simply have to share with you that every discussion I've ever had with a jury, and I see them all together post-verdict, is that they all acknowledge that if they had been recorded, that their deliberations would have been affected by that, and they would not have felt free to express the views that they did in deliberations. So let me just turn to the last method, which we refer to as case simulation. And this is really the only method in which you can look at a causal connection between a particular issue that you're concerned about in jury decision making. And the way that we do case simulation is that we have a very large number of real juries at court, and that's full juries, who see an identical case. It's an actual case, it's been reconstructed on film. and it allows you then to identify which particular factor you're interested in, and then to vary that factor. So a large number of juries will see one version of the film, and everything is identical, word for word, shot for shot, except the particular issue that you're interested in examining. And others will see a different version. And then you are able to look at individual jury decisions and the jury verdict, and whether either or both are varied when the factor is altered. And just to give you an example, in relation to that first study that we were asked to do post the Stephen Lawrence inquiry, we were able to reconstruct an actual case on film, and we varied the race of the defendant. So a large number of jurors saw an ABH case, and this was the defendant. A very large number of real juries at court also saw exactly the same case, and this was the defendant, and another group saw the case, and this was the defendant. So I think you can understand there that allows you to look at whether that one factor did actually influence individual juror decisions in a case, and their perceptions of the case, and the jury verdict. So, and I suppose I should say that our finding was that the race of the defendant did not influence the jury decision-making in the case. So I just want to say a few words about mock jury research. And what I would say is that not all case simulation research is the same. And as Lewis Ross has rightly pointed out, most mock jury research relies on volunteers. Early on, that was students, but really most people doing mock jury research now really do try and go out of their way to get volunteers who are representative of the local population. Certainly in England and Wales, our research has found that jury pools at court are highly representative of the local population. So that's an important thing to do. However, I do think there's a real concern with volunteer mock jury research, because you do have an inherent bias problem with people self-selecting to be part of mock juries. And I just want to illustrate to you one of the reasons why people who volunteer to do mock jury research can never really accurately reflect those real juries that are making decisions at court. So we asked people who had just completed their jury service and specifically had just returned a verdict and were about to leave court. We asked them to think back on what their reaction was to being summoned when the summons dropped through their postbox. And I think you can see that for the overwhelming majority of people who have actually served on a jury, their initial reaction to being summoned was not a positive one. We have a very small proportion of people who said, I was excited to do jury service, but most were not looking forward to it and were perhaps thinking about how they might avoid jury service. We also then asked the same people, saying, of course, jury service was not voluntary, but if it had been voluntary, would you have opted not to do jury service? And I think you can see there that the overwhelming majority of people who have served on a jury in England and Wales, returned a verdict, and have completed their jury service would not have been there if they had been given the option not to. So I think when you see something like this, and this is an advert that I saw for some mock jury research, particularly on relation to sexual offences, this was the advertisement that was used to entice people to come and take part in the research. So this is so counter to what you actually find in terms of the real experience of doing jury service. We don't ask people if they have strong views about crime and whether they would actually like to voluntarily do jury service. So I'll just move on now to finish up and talk a bit about the research that we've been doing in relation to sexual offences.
Yeah, Cheryl, in terms of timing, if you can draw it to a close in the next minute or so, a couple of minutes.
Okay, right. So we're using all of the three methods. So it's not just the fact that we've done interviews with people. The reason we got involved in the research is there was a petition to Parliament in 2018 that called for all jurors in all rape trials to have compulsory training, and it claimed that jurors commonly accept commonly held rape myths, and that the conviction rate in the UK is very low. So we analysed all of the charges and all of the cases where juries reached a decision on rape offences over 15 years, and this was the result. So you can see this is the combination combining all rape offences each year, and you can see that the jury conviction rate was fairly steady in the sort of high 50s and has grown quite significantly in recent years. That means that rape now falls pretty much within some of the highest jury conviction rates in England and Wales. Of course, not all rape offences are the same, and we were able to analyse different types of rape offences based on the gender of the complainant and their age. You'll see here that actually the largest proportion of rape charges that are dealt with by juries are for female children, but a large proportion by adult females. And here are the current conviction rates for jury conviction rates based on whether the complainant is a child and their age and their gender, or whether they're adults. And what you'll gather from this is that the purple side is the adults, and just bear in mind that those are where consent is an issue, whereas in cases involving rape with children, consent is not an issue for the jury to have to decide. So I know a lot of the focus, certainly on the recent rape review and now the Law Commission report, is looking at, is really just focused, it has its interest in adult female rape, and I've just provided here for you the current jury conviction rate for adult female, in adult female cases. So you've heard about the research we did, jurors' views about rape and sexual offences. I will just share those results with you. Right, so that this giving you the details of how many juries, full juries, the participation rate meant that we could have a complete picture of attitudes of each jury. So looking here, what we found is that few jurors believe standard myths and stereotypes. These very much mirror all of the myths that Penney Lewis put up in her presentation at the start, and you can see very, very small proportions of jurors who believed these myths. And similarly here, what most jurors do believe, again, these are counter to many of the myths about delayed reporting, about reluctance to report to the police, and the difficulty of giving evidence in a rape case. But we did find two factual issues where there was a substantial proportion of jurors who were either unsure or incorrect in their understanding, and that was about the likelihood of being raped by a stranger, and also about whether someone would be very emotional when giving evidence in court about the rape. So just to conclude, really based on the research with real juries at court, is there evidence of a systematic problem with juries in rape cases in England and Wales? Well, certainly from our research, we were not able to conclude that there is a systematic problem or a systemic problem with juries in rape cases. We have 15 years that show that juries were consistently more likely to convict than acquit, and that's regardless of whether the complainants were children or adults or females or males. And that rape now has some of the highest jury conviction rates amongst all offences, and that real jurors at court did not reveal widespread beliefs in rape and sexual offences, myths and stereotypes. So I'll leave it at that.
Cheryl, thank you very much. Sorry there for hurrying you along. I want to leave some time for Mary, and of course then for Q&A. Can we then turn as our last speaker to Mary Pryor, King's Counsel, a barrister, if my maths is right this time, for 30 years or so, and a King's Counsel for the last 6 of those. Mary also sits as a recorder in the Crown Court, and her chamber's profile catalogues the impressive range of high-profile cases, complex cases in which she's appeared, and she is frequently instructed in multi-defendant complaint historic sexual offences. In 2019, she was a finalist for Leading Silk of the Year, and in 2020 was a Women in the Law Woman of the Year award winner. So we welcome you this evening.
Thank you. I'm not so sure I'm grateful for the graveyard shift, but I am grateful to be here and sharing some thoughts with you, which I will, in view of the time and the eloquence that you've heard already, keep short. The reality is that for a person who has been raped, the perpetrator takes a large stone which they place in the heart of their victim, and it never goes. All of us who deal regularly, as we do, with victims of rape know one when we see one. The signs are obvious to those of us who deal with these poor people week in, week out, year in, year out. And deal with them we do. The issue for us to determine is what we can do to make sure that they stand the best prospects of a successful outcome. At the moment, there is a large truck driving down the road, which, in my humble opinion, is full of myths and stereotypes. And that truck is not helping victims. And what I would very much appreciate is an understanding of what the dangers are that can be created by people genuinely trying to help. The victims are regularly told the conviction rate is 2 or 6%. If we add to that equation the fact that only about 16 to 20% of survivors go to the police at all, and the attrition rate from that is disastrous, and the fact that half are repeat victims, we have to wonder why people don't come forward. Now, there are all manner of reasons, but recently, highly in the media, is the fact that juries don't convict, barristers are just awful, and the trial process won't help them. And so they believe, because why wouldn't they, that when they go to court, if they choose to go to court, the prospects of a conviction are low. And that is simply untrue. It's untrue, and it is dangerous, because it makes people believe before they even start going through the trauma of a trial process that they are unlikely to succeed. And that is unfair to victims, because the reality is, if we get it right, if we do the case well, a jury will convict in a case where it boils down to one person's word against another. They do it week in, week out, all over the country. I see it as a prosecutor, I see it when I'm defending, and I see it when I sit as a judge. They come along and they ask me, almost always, will the defence barrister shout at me? Is he going to wave my knickers in front of me in court? Is he going to ask me about my previous sexual history? Why? Because it's all over the media that that's what we do. And it isn't fact. Section 41 prevents cross-examination on previous sexual history. We don't wave people's knickers. And if we did shout at someone, we would be very quickly rounded on by the judge, by our colleague, and we would lose the jury. The days where advocates were praised for being loud, shouty, and dramatic have gone. The Hempel method, which we teach all new advocates, makes it plain that that is not a way for anyone to behave. These myths and stereotypes impact on people's decision-making. They impact on the trauma that they have before they come to give evidence, and they impact on the trauma they have when they're giving evidence if they don't know, because they're waiting for this behaviour. The criminal bar is shrinking. We've lost about a quarter of our members in the last 5 years. RASO work is something that I am phenomenally proud to do. It is a highly skilled, highly stressful, relentless course of work. People don't want to do it anymore. It impacts on barristers' mental health. It impacts on any time that you might have with your family. It is exhausting and relentless. And when we do it, we're now faced constantly with reading in the press about all the things that we are doing, which we're not, in fact, doing. We, I think, John and I particularly, between us, having over 60 years of prosecuting and defending for many, many weeks of the year, are in a unique position defending and prosecuting to help academics and other professionals to try and assist us to improve this system. We need to work together so that we can take the best of your psychological, psychiatric, jurisprudence, criminal law benefits, all the things that you can help us with. We want to learn. It is a new science and it's constantly developing. In return, we would urge you to communicate with us, because many of the things that you sometimes say demonstrate the fact that you do not have an in-depth knowledge of the system. And in the absence of that, it may mean making poor choices or ill-informed choices. We all work better when we work together. And I would like to learn a great deal more about the research on freezing, for example. That is fascinating. It's precisely the sort of thing that we need to work together to understand. Let me tell you a few things about jurors, and then I'm going to draw this to a close. Firstly, jurors are people. If the statistics are right, 1 in 4 women, 1 in 6 children, and 1 in 18 men have been subjected to a sexual assault. Those children become adults, and all of those people may well become jurors. In addition, their loved ones, those who they live with, who will know that they have been subjected to sexual assaults, are also potential jurors. I do not see jurors sitting there judging victims because of the way they dress or because of something that they perceive that they've done. What I do see is potential jurors breaking down in tears, indicating that they can't do a rape trial because it's happened to them. And that is becoming a frequent problem. And even that in itself demonstrates to the other jurors that ordinary people get raped. Jurors don't think it's important to fight and struggle. They accept that people freeze and may not speak out immediately, but they do struggle with other things. They don't understand that those people who have been subjected to this trauma make poor choices. They may make poor choices because of the trauma. They may make poor choices because of intoxication, either consumed at the time of the rape or often afterwards. Jurors don't understand people who text an abuser after the event, or go for a meal with their abuser after the event, or continue to see them, or are hungry or happy or sociable in some way after the event. All of those things are explicable, but they are not easily explicable in the current myths and stereotypes directions. And those are the sorts of things where I see work required. Experience teaches us that defendants and victims do not need a second audience in the public gallery observing the trial. It is devastatingly difficult enough for defendants and for victims to do these trials, because in the same way that a victim faces trauma, a person accused of rape who says that they are not guilty will have often waited 3 to 4 years for their trial to take place. In the interim, they may have lost their job, their marriage, their home, their community. A young man I recently represented of Asian heritage had been shunned from the entirety of his family because he was accused of crime. He was on bail for 4 years for a rape that was alleged to have occurred 15 years before. And after 4 years, he was acquitted. By that time, his life had been completely destroyed. Whilst it is also right that the complainant in that case had destruction in her life, we have to bear in mind that we are not there as a goldfish bowl for research. Recording of jury deliberations would be problematic because if you record jury deliberations and you listen to them, and there is within them something that might amount to a miscarriage of justice, what are you to do? What are your obligations? Any person defending in a case where a jury has convicted, knowing that there is a recording, would seek access to it. And if you have access to it, why couldn't they? That's the difficulty with it. And once that position arises, then jurors' deliberations are not private, and they have to be. And the jury system does work. The alternative of judge only is not ideal by any means. Judges are also people, and they will not want, one imagines, the pressure of having to make these decisions week in, week out. Do recall, of course, that the Lamy Review, which has been reflected by the Sentencing Council, has recognised that people from ethnic minority groups get longer sentences by judges for what appears to be no good reason. There is a real concern, therefore, is there not, that unconscious bias may impact people from that community. And that is certainly something that one of the more recent researches that I've seen has demonstrated. If you want a higher conviction rate on rape, then instead of everyone talking about how important it is that we get a higher conviction rate and why we need to get a higher conviction rate and the government giving us Section 28, etc., there are 4 things that can be done immediately which will increase the conviction rate dramatically. The first is that the police should be taught to investigate rape like any other offence. Currently, they start investigating a rape by asking the complainant what happened, effectively cross-examining her, and then seeing what they can find to undermine her credibility. That is not the case with any other offence. If that woman or man had been assaulted, that kind of delving into someone's credibility does not occur. It simply doesn't. And also the other difficulty with the police scenario is that they take the view that the investigation begins and ends with the complaint. There is often supporting evidence out there if it's obtained early. There's CCTV showing the victim before the incident. There may be CCTV showing it afterwards. These can show the demeanour of a victim, and sometimes they can show the perpetrator following them from much earlier in the night if anybody troubles to check it. The second thing is that rape victims deserve to have the same money spent on their cases as people who deal in drugs, people who have terrorist offences. The technology that we have in the investigation of rape cases is far less good than it is in drugs cases. Why? Drugs cases do not have the same outcome for people. Thirdly, the technology that the court has available is very poor. If we are going to use ABE interviews and the Section 28 process, there has to be a radical change in the way in which we do it. We need to video people so we can see their faces, hear their voices, communicate and connect with them on a level, show them where to face, show them how that we can talk to them so that they feel comfortable. Don't go in there with a clipboard into a room where you stick them on a sofa and effectively cross-examine them for the best part of an hour and a half about an incident that lasted 3 minutes. The power is to hear them speak, not to hear an officer speak. The quality of the recordings on section 28 is not good enough. It's not fit for purpose. We can't see the faces. We can't see the emotion. We can't hear it. And finally, this. It is a specialist job prosecuting and defending rape cases. It requires input from a prosecutor at the very outset of a case. We need to meet this person. We need to get to know them a little bit. We need them to understand that we are there to assist them through the trial process. If that happens, then they are on board and they understand what's going to happen, and we can present our best evidence to the court, then you will get the conviction rate that is right. But the conviction rate will not be 95%. It can't be 95% because the burden and standard of proof in a criminal trial is that the jury must be sure. If you have one person's word against another, there will be occasions when a jury cannot be sure, because remember, for a conviction for rape, there have to be two things. One, the victim didn't consent. Secondly, the defendant did not reasonably believe that the victim consented. If we cannot demonstrate that, then we cannot get a conviction. That does not mean that the victim is lying, nor does it mean that the system is failing. It means that the system is doing its job. This is a criminal trial. There are other processes which a victim could follow if they cannot reach that criminal judgment level. But again, no one tells them about them. There are civil proceedings that they can have, they can sue. All of these things are possibilities. What we need to do is work together to make the best opportunities we can to make a difference. Yesterday, I received an email from a young man, as it happens, who I prosecuted the case of in 2004. And he emailed me to say that the conviction for rape in his case had made a huge difference in his life. And 20 years on, he's moved on, he's gone to university, and he's made something of his life. That gave me such joy and such pleasure. But it shows you the time it takes. This is a really difficult work, and I appreciate and value the fact that you are all trying to make a difference. Thank you.
Mary, thank you very much. We are a little bit behind time, and I know people may have to leave, particularly because there may be transport difficulties. I have 2 or 3 questions that have been submitted online, and I'll take some. No, you can raise some questions here, of course.
Can you repeat the questions? So
I will repeat the questions from those here in the room, that they can be heard online. Some of the speakers in the room don't necessarily always pick those up. So let's take a question from the floor, if there is one immediate. So I think in short, the question is, can we trust jurors to follow the guidance they're given by the judge, the direction they're given by the judge, particularly in relation to their responsibilities in not conducting other research and so on? I don't think even in your radical chapter, there are suggestions for jurors now being sequestered and kept in hotels. I don't know whether anybody online wants to address that. Is there more that we could do to ensure that jurors are faithful to their oath? Is that a concern that any of the practitioners share?
I think, David, I think that generally speaking, and I think Mary's got the same experience. Generally speaking, I think that jurors do follow judicial direction. Of course, there are examples, and indeed judges tell and warn juries about other instances where jurors have, in particular, have gone looking things up online. But I'm absolutely convinced that in the vast majority of cases, juries do, because they're given very straightforward, very clear written guidance. I think that there are good reasons to beef up some of that guidance and expand it. the judicial directions, especially on behaviours and so forth. And I see no reason why that shouldn't be expanded. But generally speaking, my experience is that they do abide by judicial directions.
Right. Can I deal with, I'll take one more question from the room, and I've got 2 or 3 online. So again, to summarise that, without, I hope, losing the nuance, would it be an advancement to allow an expert to give evidence before the jury, not of the behaviour, if I've understood this, not of the behaviour of the particular complainant and the circumstances of the behaviour of that complainant, but of general understanding of psychology and indeed neuroscience, that our typical understanding, we could agree a consensus across psychology and neuroscience and elsewhere, our understanding generally is that the following expectations are misconceptions, and that there is there may be an expectation among some jurors that this would be the typical response, but you should ignore that mythical or misconception because the science and the psychology just does not support it. So should we allow an expert to give that general background evidence in that way? I don't know if anybody, I mean, this is something that you address in the paper, Penney, so perhaps you'd like to say something.
I mean, we are consulting on that, obviously, as I mentioned, and I think you're right that aftermath behavior, which Mary prior mentioned, is something that could form part of expert evidence on sort of so-called counterintuitive behavior. So whether that's during the assault or after the assault, whether that's, something that, maybe is more widely understood in society now, that individuals may not report immediately, or whether it's something that's less well understood, like, for example, continuing contact with the defendant. So yes, we are looking at that. We are aware that there are arguments against it. There are concerns that have been raised with us about unfairly bolstering the complainant's credibility using this kind of evidence, even if it doesn't, as we suggest, even if it doesn't deal with the specific facts of the case. There are also concerns about the trial becoming a battle of the experts, and we end up in a situation where trials take even longer than they currently do, and we're in a big backlog. So is that viable? So I mean, we can see the arguments for and against, and we'd really be interested in views.
Could I comment briefly on that? I think I would want the answer to your question to be yes. So I would want to believe that rape and sexual assault are human behaviors, and they're products of the human brain, and they have a neurobiological reality, and there are facts about human behavior and facts about neurobiology, which prima facie would seem clearly relevant, and there ought to be the possibility of establishing knowledge or knowledge bases. You won't have facts about this particular incident in that way, but you'll have facts about the generalities of behaviors. Those facts may well have a strong layering of things like social and cultural specificity as well. But given that social science is kind of there, I mean, it's right next door in most universities, and given that neuroscience is there, and given that those people claim to be seekers after truth, one would hope that there should be relevant facts. I think one would need to proceed extremely cautiously in establishing what those facts were, how they're being communicated into the legal process, and why. But if there are no facts, or if there's no possibility to have the legal process informed by them, it would seem odd. It would seem a disconnection of knowledge, which would not fit with the kind of society I think we would want to live in. So I'd like it to be possible to answer yes to that. How one would go about it administratively is another question.
Cheryl, did you want to come in on that as well? I see a hand up, or was that in relation to the previous question?
But no, I won't mention it. I want to come in on this, and I think I really want to come in on what Patrick was saying, and just I think it's really important that everyone realizes that this type of factual knowledge there are mechanisms for this to enter into jury directions that are provided by the judge. I would really encourage everyone to go to the Crown Court Compendium and read the sample directions that judges give to juries in relation to the whole range of what are called false assumptions. A number of these cover what are known to be widely agreed factual or scientifically based evidence. And that's the barrier that has to be overcome. And there is a huge amount of work that goes on behind the scenes that people won't be aware of, involving the Court of Appeal, involving people who are working on the compendium, involving the Criminal Procedure Rules Committee. These issues are looked at across a wide range of legal professionals in order to get to the point of saying, right, all right, there is widespread agreement on this issue. This is something we can say to the jury. And I think it's also very interesting. We've had numbers of studies on this, particularly in the US, in relation to other issues, not related to sexual offences, but for instance, in eyewitness evidence identification. And there numerous Supreme Courts in those states have studied this in great detail and have come to the conclusion that the best way of communicating this to the jury in the way that they will understand and also take on board is for those directions to come from the judge and not from experts. Because as you said, this may get into the battle of experts. Penney, if you've raised that issue. And I think I just really want to encourage people to look at the directions that are already there and to understand that this is an ongoing process within both the judiciary and other aspects of the legal system to identify where are we now on safe ground, that we can say to the jury that this is now agreed medical evidence or neuroscientific evidence. And I think, Ebani and Patrick, this is why your research is so interesting and so important and does need to feed into the always evolving directions that are given to the jury.
And on a very practical basis, and I'll just be very quick on this, practitioners should be raising these issues with the judge at the close of the case. Before summing up. And in fact, in my other little specialist area, abusive relationships, it's quite interesting how we're willing to adopt a whole raft of concerns about counterintuitive behaviours in domestic violence, as it used to be called, or abusive relationships, as we prefer to call it, in order to demonstrate, in fact, that the offence has happened, because the counterintuitive behaviours very often indicate the fact that the abuse has happened.
Okay, thank you, John. I'm going to deal with a few questions from online. Cheryl, I've got one specific question for you, which is if you could explain how you can counter the argument that when jurors are questioned after the trial, when they've been given a misdirection, they are likely to comply with what they perceive to be the questioner's request. So that this argument about social desirability bias, I suppose, is what this question is driving at. If you've been a juror for 2 weeks and you've been told by the judge that you must behave appropriately throughout, you've finished your jury service, and then you're immediately dealing with a series of questions from a researcher, is there a risk that you will tell the researcher what you think they want to hear rather than your true beliefs?
Okay, yeah, I've seen this referred to in a number of instances. Also, I'm very intrigued by the idea that if you have a 99% response rate, that's an indication that your results are unreliable. That's a really interesting one on me. Right. What I would say is, for people who are interested in doing jury research, you should go to jury trials. You should sit in the jury lounge. You should see what jury service is really like. A jury that's been doing jury service for 2 weeks is going to be generally a pretty confident jury who is not going to be pushed around by any researcher. You also have a very interesting sort of phenomenon, which is people who do jury service. I didn't share some of the other research results with you about the impact on individuals of doing jury service, but I will say that 87% of people who would have opted out of jury service at the time they were summoned turn into 81% who would be happy to serve again once they have completed their jury service. It is transformational, and what you have to understand is, for a lot of people doing jury service, they're doing their two-week trial, they've returned their verdict. It's very, it's quite an important resolution of this experience, they often just go back to the jury lounge, are handed in a form, and then it's over. And most people are sitting there thinking, I've just done this amazing thing. Surely someone wants to ask me about it. I have views about what I've done. I have views about how this could be made better. So actually, this is not the idea that you've got 12 people who are somehow subservient to a researcher is really, frankly, very misconceived about what jury service is like and the impact that it has on individuals. I also want to say one last thing, which is I have no idea who these jurors are. They know that. They know who I am. They know I am doing the research. They know it's completely voluntary, and they are under no sense in which they're compelled to do this. There's not some jury official standing there, and it's made very evident to them that it is completely voluntary and there is no penalty or anything else for them not to take part. The reality is they've done something quite amazing and probably transformational for them, and they want to share their views about what that experience was.
In view of the time, what I propose to do is I'm just going to read out very quickly or summarize very quickly some of the questions that have been posed, and then perhaps they can form part of the broader debate. So in part to draw to your attention. Actually, the first question is for Professor Haggard, which is, in short, whether or not your research would carry over to work in relation to those who've been the victims of serious physical assault or strangulation, and whether you see the same. That's from Professor Susan Edwards, who is online. A couple of others, which are, I think, invitations for the Law Commission to be cautious, that we don't strive for a high proportion of conviction rates, and in doing so assume guilt and throw the presumption of innocence out of the window. And I know throughout the paper you're very cautious to explain that this must be balanced against the defendant's right to fair trial.
And can I just say one sentence, which is, increasing conviction rates is not the objective of this project. It never has been. We're not looking at that. We're not trying to do that. And while obviously other people are, free to discuss conviction rates, that's not what this project's about.
And the penultimate one I have online, a disappointment or surprise, I suppose, that practitioners were suggesting the system isn't as broken as it is. Perhaps that's too political to deal with in the next 30 seconds, but I'll put out there for later discussion. And finally, I will simply raise this. Is Section 28 working? This was something that the criminal practitioners will certainly have a view on. The report in the Times today suggests a very low take-up rate. Is there a low take-up rate? When it is taken up, does it work effectively? They're huge questions. We don't have the time to address them now. So having simply alerted you to those, can I draw proceedings now to a close? First of all, by thanking our speakers. And online. Secondly, thank you to the team, the events team here, Lisa, Kat, Maria, and recording for their efforts in making this work as effectively as it has. Not easy to run hybrid events when you've got people from literally the other side of the world online as well. So thank you very much for doing that. And thank you to all of you for attending, making it such a stimulating evening. There are, for those of you in the room, there are, I think, some refreshments outside. For those of you who've been joining online, then I hope you've lined up your own refreshments. Thank you very much for coming. And please do keep an eye on the UCL events website for further events in the laws faculty. Thank you.
Thank you, David.